he got it. When he on to the above subject, refer to the have been issued to so and so, but from this copy of the reply is an application made before the Todubura size range. Then your document ID C, the fields I have produced is marked as
62.
that page.
That's certificate.
Certificate, no. The one I have produced as the one below at page 37.
37.
Yes.
Let's say
15 trees earmarked to us. Robert Chaco is not there.
Only 14, so only 14 you will give.
14, not there.
and filing process. In the meantime, the petitioner is directed to deposit the decretal amount, compensation amount, with up-to-date interest in the registry.
It's already deposited. Please produce a certificate.
In the meantime, the amount invoiced by the petitioner in terms of the order date 13/10/2023, right?
Yes.
Passed by the PCC shall not be employees' compensation shall not be released in favor of this. Thusly, as well to the returnable date.
You can continue.
Well, in this consent petition, some amount has been received yesterday.
This one. Yes, now tell us.
Yes, some amount has been received yesterday in this condemned petition to the deceased workman's wife. There seems to be some difference in the billing of the remainder. We have just received the calculation chart today. We got 10 days time to be given.
The counsel for the petitioner states that on instruction that some amount has been released by the respondent proposed contemners in favor of the petitioner widow of the deceased employee. With a computation.
There's some the market
Is point out directly.
You paid yesterday.
No, the sum amount. Otherwise,
No, you paid yesterday only.
yesterday we received.
After 1 year of the deadline.
only return amount 1% of something.
But whatever it is, tell him don't wait for the date to say if there's any.
Because actually, once the payment comes, it's the union which is taking out the matter. They check up with the widow.
Why
there.
not?
I will.
Check up with the widow. If there is a discrepancy, tell your colleague.
I will.
Yes,
Not on the next date.
Absolutely. Before the next cycle will be done. Great for minutes.
Much of it. 25.
Yes, 25.
So last order has been complied with during depositing on 19th February.
You pay deposited the amount. Where is it? According to you, on payment of this amount, there are no arrears. On payment of this amount, there are no arrears. Then now tell us. Any issue from the marriage?
So how is there 14? Yes, but you filed a petition for divorce only in 2018. 18 you filed.
You filed the divorce petition on 23rd April 18.
Separation from the year 2019.
Let me have the mobile switched off wherever and left, right and center. Notice. Give a returnable date. Next. Yes, please.
Pension matter whether they're ready.
Yes, yes.
Now the review is also there.
Clarification. The notification of 28/3/2005 was notification, whereas the order 8/4/2009 is only an order.
Yes,
Am I correct to that, actually?
yes.
What is the number? I don't see.
That's correct.
Where is the number?
So the notification cannot be watered down by an order.
Yes, yes. It's an order, but the 8/4/2009 is the order.
And that was a notification.
Correct.
And the other point is that previous service has been counted for the purpose
That's right.
of gathering.
And
That notification.
Incorporated, you're being covered up by that.
Correct, correct.
So
That's
that's
the whole point.
right.
26.1, 26.1.
Yeah, right. Right, yes, yes. Issue notice. Yes, issue notice. Anybody there on the other side? Nobody? Issue notice to the.
notice on review as well as the maintenance. Kindly make it returnable in 4 weeks or 6 weeks.
How will we issue notice on the main petition? We'll have to issue notice on the.
No,
Other petition.
Other petition.
Other petition. Notice in the review, and in the other fresh SLPs, your lordship may issue notice and tax order.
What are the numbers of the fresh SLPs?
Item 26.
4684.
Yes, carry. This is 26, right?
Yes.
Issue notice in 26.1 on the review application and notice in the main petition as well. Is there any delay, 30 days delay in condone it in filing, which in the. Filing delay. Condone that and, yes, condone it and, say that PF, do you want to file, take dusty as well?
We'll take it dusty. And kindly give a returnable in 4 weeks or 6 weeks.
That we are not sure.
Correct. These are pensioners.
It's only pension.
Yes.
Once we find that. Once we find the detail test. Once the calculation is this. That there were originally 78 workers,
Yes.
out of which 36 were regularized.
Just give us the detail, just give us a moment, we'll just pull out your app. Yes,
Once we find that supplementary evidence.
Yes.
I think that
total 78 casual workers.
Alex. There were 78 workers. It starts off with at para 2.
Right.
Total of 78 casual workers issued by the regularization. Then, over the page at 2, 3, during the pendency of the dispute, 36 casual workers were regular. So that takes 36 out. Then 22 never turned up. They did not strike a claim, they were not interested in it. So that left 20 workers.
22 never turned up.
Never turned up. We said that on epidemic.
Where? You said it's 20.
22. Will come to page 5, para 9.
Why don't we go to page 2 first? We are going in seriatim.
I'm just bringing that calculation to 78, then I'll take Malos.
Para?
Malos will come to page 5, para 9. So 20 is gone. So 36, 22. So that leaves 20. Now, when we asked, now there was an architectural order. So there was an industrial court order, tribunal order asking them to regularize 20 of them.
Separate order.
Separate order. So that we said. And page, in the original, that is page 74.
Para 4, what is it?
Yes, so we said that in para 4.
Page 2, para 4 of the
This is going to IITR.
Yes, well, these were actually transferred to IITR. But they asked for regularization and the industrial tribunal granted them regularization. And the High Court confirmed that. And
You are agreed by this one?
yes, these 20, because after regularization, they come back and say, and we regularize them. So they come back and say, give us back wages also. We say no, that you've been employed at IITR, so you are not entitled to no work and no pay. Now, at no point of time.
So when they,
Yes, sir.
they were transferred to IIPR, did they report? You're saying they did not report?
No, they never reported.
After 11/7.
Yes.
So how did they file a petition saying that?
Because they said that they were part of those 78, so they were entitled to be regularized because 36 had been regularized. That was their argument. Now, both the High Court order, I'll take, and the tribunal order, at no place of time, and no point of time, decides on this question of back wages.
Your grievances only back wages.
Only back wages. Because we regularize them and we dealt with them. We dealt with them at page 3.
No, back wages, Mr. Banerjee, will come only when you admit that they have finally rejoined. You said they have not rejoined. So still you are
But they
in the denial mode.
No, what happened is they got benefit of that order. Now we regularize them.
No, but they never joined, so how could you regularize them? We are not
Because 78, what the court held, was the tribunal held at page 74.
There are total 78 words.
Yes.
Right? Subject
Yes.
matter of regularization by virtue of OM of 1310/80.
Yes.
Right? You are saying out of these 36 were regularized. No dispute on 36
Is out.
out. You said another 20
Did not
join.
join.
Now,
Did not came at all. Did not come forward.
Did not, even the 20 you are talking about neither worked in NSI nor reported in IIPR.
Yes.
Why will you question only back wages?
But what had happened in that, they had
You will say they were not entitled for regularization. If you were to understand correctly.
that we had in our contention. But when they approached the tribunal, and the tribunal held against us, saying that these 20 are entitled to be regularized. And the High Court held against us.
You haven't questioned their entitlement to regularization in the High Court.
No, we granted them regularization.
No, Mr. Banerjee, we are jumping back and forth. 76 are directed to be regularized.
Yes.
Okay, 78. 36 you regularize.
Yes.
20 you say never joined.
22.
I said, but how can they join unless you issue a regularization order? You never issue that order, but you say they don't come and join.
I'm just clarifying. Okay, I'm not clear. So this 20 did not join. But
Was there a regularization order passed prior to that? Then only they joined. Otherwise, they are already out.
then what happened is the industrial tribunal, I'll take one.
No. Again, this is the catch, Mr. Banerjee. 76 were directed to be reinstated regularized. You issued orders for 36.
Yes.
20 did you issue orders or not?
Yes.
How could they come and join?
Now we have.
Now you have. So that time they could not have joined because they had not issued an order.
That's what we are saying. Neither the tribunal. What is our primary contention?
But Mr. Banerjee, you cannot say I will implement in 36, I will not implement in 20. That was your fault. So why should they not get back?
I'll answer that question because, as we said, they came under 33C2. Lordship will see that. That was my first.
Finally, the High Court held holds against you.
In 33C2, the Bombay Chemical said that you can't go behind the order. You cannot make your own calculations. Bombay Chemical says.
Not a
calculations have not been given by the industrial court or by the High Court in that order when they asked us to regularize these 20 people. You cannot get it done.
Mr. Banerjee, you may have. No. Oh, so you mean to say that prior to the passing of that order, you will not give an entire till the time we have passed. There you are correct. On that day when 76 were directed, you issued order for 36. Behind that, they will not get. But if you have sat on that, you have not issued their regularization order till date, then that period there has to be paid to them.
Mr. Banerjee, just.
There are two separate things.
We granted them. We have granted them from the date of the High Court order.
No, that will go back to that.
Mr. Banerjee,
Languages from that.
So we are asking you again.
Yes.
Out of 78, when 36 were regularized, why did you issue regularization orders for the remaining?
Well, because 20 had moved to Pulse Research Institute. Because we had an agreement. We enclosed an agreement.
You had to take a clarification, or you had to tell the court that look here now, kindly act them as a party. You cannot remain sanguine and say, okay, will be nothing to do.
These workers were transferred along with the land. I take my look at that.
If they were transferred with the land, these workers to that other organization,
Yes,
workers were aware of the fact that they were to
yes, of course. Well, that's part of the agreement.
With some settlement with the union?
Yeah, with the, I don't know whether there was settlement.
No, then there you can't throw the onus on them.
There has to be some settlement with some agency for them to know where are they to report.
Well, if Lordship wants us, whether we put them on notice at that point of time.
Yes, so then we knew they were joined and they didn't.
You will not be satisfied
Right.
prior to.
Well, my submission is twofold. I appreciate what Lordships are saying. I appreciate all this. According to us, will recall my first submission on the first day was that if the High Court or the Industrial Tribunal does not give them back wages, then the under 33C2 of
We are with you, Mr. Banerjee. Who's disputing? You are now trying to create a court. But from the day the industrial tribunal passed the order, from that day, that will not be termed as back wages. Back wages will be between the interregnum till the industrial tribunal pass that order. So that will be the period of back wages.
What?
We'll have to redefine that back wages period. This will be because from that day, your liability to pay starts. Regularization. You don't do it, and now you say it is back wages. You can't bracket it as back wages.
Unless you show
That is the
that
simple point.
they didn't join.
Okay. Then they did no work, no pay. You are right.
You're
But
right.
if you did not do, you admit that you passed an order after the High Court, so that will not be bracketed as back wages.
I'm only saying that if there was back wages, my submission is this, that if back wages were to be granted to these specific people, then that should have been a part of either the award or of the High Court.
Who is disputing, Mr. Banerjee? You are right. Who
You're
is
right.
disputing?
Now, next step. Okay, it could not be part of, if it was not part of the award, High Court could have awarded
Yes.
it, whatever. Tell us, did you take any steps to tell these remaining, besides 36 who were already regularized by you, 20 plus 22, come join? And they didn't. According to you, 20, there was an agreement to join IIPR with whom? IIPR or with them?
So with IIPR, say that.
How did they know?
That is not on record.
How did they know? Will you file it?
That's what I'm, Malas will come to my agreement. I'll just come, and Malas, I'll just take Malas to the lease agreement.
All
Now,
right.
have you understood the query of the court, the doubt in the court?
But I appreciate what Logic is saying. Did they?
Back wages, in the sense that on the day the award was passed, no back wages allotted, they will not get of the prior period. But on that day, the clock stopped. From that day, everything is admissible. You delay in issuing them an order for regularization, so that will not be termed back wages. This will be part of the award. So there is no question that they could not have done what was not awarded, not required to be awarded.
What was the date on which the tribunal passed that order?
So 7/7.
7/7/2008.
7/7.
So the clock starts ticking from 7/7/8.
Nothing prior to that that is back wages.
98, 88.
Malas, tribunal, what it does, Malas, will please come to page 74, Malas, at 74 of
Okay, annexure P3.
P3, Malas, at 74, this is the tribunal.
Let us have a look at it. Maybe there's some
The reasons discussed.
clarity will be there.
Malas,
Yes.
what it does is ask us to everybody, 78, at page 74,
Yes.
and page
Appoint
24,
78 workers
casual workers,
listed in the
with neither legal consequences for the
They are entitled to
regularized.
regularization.
Malas will then come to what the High Court orders at 79.
79. Okay. Yes, please. 79.
This is in relation, Malas, the second paragraph of 79. This is in relation to these 20 people. And that's why we are saying the clock starts from here.
What is
Having heard the learned counsel for the parties and having perused the material record, I am of the opinion that the award passed by the Labour Court is just and fair. It upholds that. The 20 workmen, so this is where we are saying the clock starts from here. The 20 workmen had accrued to them under the office memorandum.
20 are besides 78?
No,
So
included.
this is the 20 which is disputed. This is the 20 which is
Right.
The 20 workmen have wrongly been denied the benefit which had accrued to them under the office memorandum so and so, and even taking into consideration Uma Devi, they ought to have been considered for regularization. The petitioner ought to have considered the claim of these workmen for regularization in pursuance of the office memorandum dated 1310. And we use this, then we take it up to Supreme Court, we use this. But according to us, this is where the clock starts.
Sorry,
No,
Mr. Banerjee.
that if you are saying that, then this is a case of dismissal. If you would have said that the 7/7/2008, you challenged it as a different matter. The tribunal gave benefit to them on 7/7.
And it has been upheld, just and fair.
Yes,
Court
so
says
High
it was
Court
just-
turned down your plea doesn't mean your clock starts ticking from the order of the High Court. It relates back to
It
7/7.
in fact upholds that original award.
That is what we have
13 won't engage us.
Malas, what we have done, Malas will come to, Malas, what we have done is at page of the additional affidavit at page 3, Malas.
Yes, what have you done?
So, this is how we have dealt with them. We now regularize them, so there is no question.
No, those 20,
Yes, we now regularize.
you may have done it now. Doesn't mean that you do it now, all the illegality gets washed away. They were entitled on 7/7/8. You tested that judgment. The judgment came by the High Court in 13, and that Supreme Court refused to interfere. In other words, what was ordered in 7/7/8 stood as it was. So everything relates back to 778. So what did you do?
According to us,
You did nothing. Sorry, no merits.
No merits from plan.
Please come. We have regularized them from 778. We regularized them from 778.
You were required to.
Once the whole question is,
Not pay. It's not called, can't be termed back wages. It will be payments due from 778.
Prospectively, after the award.
On the award being passed.
Right.
So they're not working is courtesy you. You should have taken them on saying without prejudice, we have answered. Second question. When you approached the High Court and filed a writ petition, assailing the order of the tribunal, was there a say operating in your favor?
No stress.
In other words, they should have been on board from 778. You chose to keep them away. That is your prerogative. You lost before two courts. It relates back to 778. Simple.
Mullahs will then observe, Mullahs when lordships are observing, whatever lordship may be, peace mission with this together. That they will not get anything beyond.
What are they trying?
Because their original claim is they should get it from the date of backdated from the time they were employed or from.
No, we'll only clarify that the act to the award, this is the date. No, but they have not, where is it? Where is that claim?
Well,
They have not come for any clarification.
Which forum have they approached saying
Yes.
we are entitled to amounts prior to 778?
Yes.
There were total.
Any forum where they were approached saying
Yes,
in execution give us something?
Well, what we have said, and Malas will see at page 1.
Then we have to issue notice, otherwise we don't have to.
Malas,
We only clarifying it.
page para 2 of the additional affidavit. Malas,
Yes.
that's where I get this thing from.
Yes.
The petitioner were a total of 78 workers, was issued based on a said claim. He filed a claim for regularization. When an OM filed a claim for regularization before the so-and-so.
No, but what is it saying? It's not saying that
Okay,
they,
what you're trying to,
One second, Malas, just a second.
if you're in a position to say that, we understand.
This is Malas at page para 10.
Para 10 of the same affidavit. Okay, para 10.
Malas, exactly. Malas. I remember I've seen it somewhere.
What?
Malas friend has pointed out. The said Malas para 10 last.
Of the date of 83.
Yes,
Para 10, last sentence.
last sentence. Yes.
13, 10, 18.
Yes,
Right.
I had read it. My non-friend was.
Yes, you're right. Your colleague has refreshed your memory. Take down. An additional affidavit has been filed by the Petitioner Institute in terms of directions issued by this court, stating inter alia that there were a total of 78 casual workers who were working with the petitioner. Stop. An OM dated 13/10/83 was issued by the government regarding regularization of casual employees on Group D post. Stop.
it is from the date of the appointment or from the date.
Or the NF appointment or names of them, or names. They want to relate that to 83, not to 83.
We do that now, with the
Yes, based on the said OM, 78 casual workers filed a claim for regularization before the CGIT Kanpur by raising an industrial dispute. Stop. During the pendency of the dispute, the petitioner management on its own proceeded to regularize the service of 36 workers against normal vacancies in Group D post para. This left how many? 42. Just 1 minute. As directed, they should be given similar treatment for those who recognize the difference between the two sets.
We'll just,
Only thing is, I don't know whether we should do it behind their back. That's about it. And if they appear, you'll have to pay their expenses for appearing in this proceedings.
they have not challenged
Because
it.
they are only saying, or they are in para 10 saying back wages from the date of their appointment or from the date of OA, right?
Yes.
Date of appointment would
That
be
was a
8.
claim before the
It will be
Labour Court.
83.
Initially.
Yes, now it
83.
is
Now,
relevant.
para 11, tribunal denied benefit of back wages for the period for which no services were rendered,
Okay.
right? Thereafter, in High Court, while allowing the petition filed by workmen directed, they should be given similar treatment as those regularized in terms of award. They were regularized from
Well,
778.
78 was some of them were regular.
No, 36, you have regularized 36 with the backdate effect. Have you paid them back wages or not? Those 36 which you have regularized.
Regularized in terms of para 3.
36.
Para 3.
So now the High Court has only said that in terms of award dated 7/7, what you have done to them, you do to them.
Mr.
What is
Banerjee,
the
confirm it, we will not take the notice, get instructions. What was the salary paid to those 36? So either
Effect from which date?
or 36, you don't give a date.
Malas will tell. Malas, they have.
It is only that whatever benefit you have given to them, 7/7/2008, exactly they account by the same award, Mr. Banerjee. It's the same award the High Court has clarified that whatever they got, they will get.
No. I think there's something more to it. Correct us. This is really becoming a jigsaw puzzle. 7/7/2008 is the award. You don't wait for the award for these 36. You go and regularize them, saying they were normal vacancies.
So these
prior
separately.
No. We are want to understand. Prior to 7/7/8.
Yes.
Which means these workmen who are claiming back wages say either treat us as regularized in terms of the OM of 83 or those who were regularized in terms of 7/7/8. So these 36 don't come into the picture because even they are not saying in terms of the 36 who were regularized earlier to 8. Are we right?
Yeah.
So 36 go out of the window.
They made a contention that you regularize 36, you also regularize.
Whatever, but 36 was not on which they're laying a claim, the date of 36. They are laying a claim saying those who were regularized either in terms of OM or in terms of award. That means either in 83 or 2008. These are the two cases that they engage us, right? Nothing more.
And High Court has clarified that you regularize them in terms of the award 7/7/2008. So there's no question of back wages. There's no question of back wages behind
We
that.
are claiming is Malas on.
They have not filed an appeal.
It goes back to my original contention.
After the High Court order, where have they filed? After the High Court has now clarified. That is the last order.
Workmen to this court means making them go through a whole rigmarole.
And in the
where are they
court,
claiming? We will then pinpoint.
After the High Court order, show us where they have. All that is history. All that is
the application. Malas will application. Malas will just where is the application? I'm sorry, Malas. Application 86.
86.
86 is the application.
Filed by them. Where?
before the industrial
No, this is nothing.
2000. That is history now, Mr. Banerjee. Now the final order is the High Court order.
Malas will see at page.
Is there any execution they filed where they're saying we want it from the state?
Yes. Malas will see. That's what I want to show.
Where?
That's what I only have to show.
Yes.
80. Malas will see the application. 1 second. Malas, I'll show Malas. Malas will please come 87. That's the application which they have filed. It starts on 86. This is the application. Employee did not pay salary that the plaintiff along with that the plaintiff has for. Malas will receive a total amount of 38 crores, 967, 38 lakhs. Let's see that. Photocopy the receipt.
That doesn't show the period.
Malas will then, I'll take Malas on that. It's also entitled to 18% interest.
Chart.
Then Malas, that chart. Malas, it's like down in my thing, but we'll see 38 lakhs. It starts off in 1970.
Mr. Banerjee, after this, the High Court order came. All this is history now. The High Court order came in 2023.
This is a 15 application.
15 application.
This is what we have.
15
They
applications.
have not come in appeal that we want the High Court after the High Court order. They have not filed appeal. You are creating a
We'll
problem.
dismiss it. We'll give you liberty. Keep that window open for you because we don't want them coming on. What we do is, we're going through the affidavit. We are not convinced that there is any merit. However, if the liberty is granted to you to approach the court in the event the respondents, the workmen who are left, those 20, demand their back wages for a period prior to the date of the award. That much. That give you a window. Okay.
That we give you that.
Cancel the order.
Mr. Banerjee.
we can just let us see the improved
Verify
order.
that
Maybe we
last portion, what you have quoted in para 11.
Our concern is not you. You are a marathon. You can come anytime and go anytime with the kind of finances you have. The workmen are the ones we don't want.
So we clarify that this would only mean that
Your anxiety we will record.
back
and
pages prior to 7/7/2008.
that where say that produce an affidavit, additional affidavit filed by the petitioner management and find that the and are of the opinion that, and as also they viewed judgment and are of the opinion that there is no, we are not inclined to interfere in therein. However, the anxiety expressed by learned ASG, the effect that the 20 workmen referred to in para, we will specify, referred to in para 4
Yes.
of your additional affidavit?
Yes.
Workmen referred to in para 4 of the additional affidavit who were transferred by the petitioner to IIPR would not be entitled to back wages prior to the date of the passing of the impugned award dated 7/7/2008 by the Industrial Tribunal in Industrial Dispute number 90 of 1986, as would be apparent from the operative para of the impugned judgment.
Right? Classifying back wages. We classify dues because back wages.
Back wages, other dues, stroke other dues.
Dues, fellas, because Lordship classified the back wages, then this,
Other dues.
none of these orders have actually given back wages. That was my initial contention.
So back wages, stroke other dues will take care of it.
Dues would be.
No, Mr.
Why?
Banerjee, then the continuity, you say that continuity also I will not maintain. They are being.
It is a word, it's wages.
Only wages.
Wages, fellas.
Don't say back wages.
I'm saying only wages.
Don't even use back, don't use dues.
Prior
just
to
wages.
2000.
Right, yes, that's it.
That's all.
Control the details. Next.
License.
48.
Well, on the last statement, officer,
Yes, please.
on the last statement, officer ordered the AR to present manner. On the last statement, officer ordered to the AR to present manner. His material melody is through online melody.
Doesn't matter. We don't want him coming here if he's not there. Please tell him to connect. Is there somebody? Just see if he's there on the screen. Is online? Can we connect it?
Whom we had asked.
Give us a recall.
Malord,
Give us a recall.
Malord, I want to withdraw the petition on the last.
Advocate on record. Advocate record is in.
Yes, ma'am.
Yes, madam.
Why did we ask for his presence? Please just remind us.
I'm not well, madam. I am in my native place.
No. Okay.
Malord, the incomplete case was filed, Malord, inadvertently, Malord. The case was filed on online, Malord. However, incomplete case has been filed. Malord, there were two files to be uploaded, but my colleague, Malord, has uploaded another file, Malord. Incomplete file, Malord. So on the last date, I requested before the court to withdraw with the liberty to file a fresh, Malord, as some of the documents and the orders which has to be challenged that has not been challenged. Malord, my sincere apology, Malord.
Mr. Kaushik, you're not well?
No, I'm not well for the last month, my lord. I've got so many diseases. I'm 86.
Okay. We understand.
All right. Take down. Say that the learned AOR has, in terms of the order passed on the last date of hearing, the learned AOR has logged in virtually and states that he has been indisposed for the last several months and unable to attend to his work in court. His physical presence is dispensed with. The learned counsel for the petitioner states that may be granted time to what all do you want to file?
Malord, I with the liberty, Malord, file the fresh, Malord. I said,
Withdraw this and
yes, ma'am.
fresh.
With the liberty, Malord. Malord, because the judgment which has to be challenged, that has been annexed, Malord, but that has not been challenged. Some of the documents which has.
More or less, you were in time filing this. Only 26 days was delayed.
So it's time to withdraw the present appeal due to several errors that have crept into it and on account of the fact that many of the documents required to be filed are not part of the SMP paperwork. While reserving his right to, the right of his client to file a fresh petition, a fresh SLP, a selling fee impugned, order dated only 22nd, right? 22nd September 23. That's your granted petition is dismissed as withdrawn. Along with the pending application, we granting you the.
Great to know.
Please, Your Lordship.
Yes, sir. To apologize for the confusion that was lost.
Your colleague really made life very difficult for us.
I apologize.
It was very unfortunate the way you went about it. It's a different matter than finally it was the Bar Association that we rushed to for taking his cause up. That's not appropriate. We don't appreciate it.
Your Lordships, we talked about that and I have come to.
If he chose not to brief you, it was his prerogative. We should have been ready with everything else.
Yes, Your Lordship.
Then why is it that he did brief you for that date? First he told us that there were no regulations, he needed time to produce them. Then when we pressed him, out came the regulations from his own file.
That was the turning point.
You know that, Ms. Datta, we don't behave like this.
You have to be fair to the court. I
Yes.
keep telling it, no matter what, leave it to the discretion
Yes.
of the court. Have faith in the court, but you cannot play with the court. He said, we have to get it, I have to get it. That was really, I was also very cheesed
Your
off.
Lordships, I heard about it and that's the reason.
That
I
is
wanted
absolutely
to
not
first,
so.
I was told on the last occasion that it has not been filed yet, so we'll be taking time. So that was our.
Isn't that very presumptuous? Knowing the matter was listed after a month,
Your Lordships, that's
and we
their choice.
brought it into this court. That's his choice. He doesn't want to engage a senior. Good luck to him. You're not here to espouse his cause for engaging seniors. Then he should have been ready.
Yes, Your Lord.
Really sorry.
And after 1 hour, it was taken up. When we had made it clear, no adjournment. After 1 hour is enough to prepare. And
After
then,
he was briefing,
after some argument,
better than him.
yes, after some argument, he also is there to understand if he had difficulty, but he did not try, he stuck to his gun, no passport. When it was refused, then you can't expect the second time.
Then we asked him to argue, out came the regulations. Then
You should have started, had it been like this starting.
Years at the bar comes, how many years at the bar? 12 is a long time. It's not 12 months. It's 12 years. And then you created a right royal shindy, went all over the place, bothered our court master, chewed his brains. We went back home. I was flying out of the city, we had to change the order. Where? On the graft. This is the extent, Ms. Makija, we want to point out.
Yes, Your Ladyship, I was.
Not
Why look
very-
tight? Right?
Very unfair.
It's a pit. But for the interest of the party, we wouldn't have given him a leeway.
Ladyship, that's the only reason I'm not hearing today because that leeway being given. Your
And then taking the bar up matter with the Bar Association and getting them all to come like a ton of bricks with my colleagues.
This was not fair. They had to approach, he only should have come, not with that association thing.
Bar Association is to take up a cause of the
And
council.
I would have really shown them the door, only because of compassion to the client.
To the party.
Otherwise, I don't tolerate this.
This is
To
straight.
be very clear.
12 years to experience, no shock.
Only
We would have
because of
spent a lot
cordial relations with the bar, but I don't tolerate this nonsense.
fair.
Like that part I'm not aware.
And we are telling you now.
Why are you coming without being awareness?
I am so sorry.
It's your duty to be aware. Once you have been aware, you have to be fair, at least to you.
This is the
If
really
you are not fair
amazing.
to me.
And normally
Right,
this is
what?
not the way we go, you know this court. If it's a youngster,
Everyone-
we'll give a longer rope. Why? Because we want to encourage the bar. It's our duty to encourage the bar, create the next generation. But those who have an experience of over a dozen years coming back and doing this to the court, unacceptable by any stretch of imagination. Yes, please address us on merits.
Yes.
Please, Your Ladyship.
Mr. Rajitra, you are.
I have also been engaged in it. I have no idea about what has transpired earlier. My friend has not.
You're wiser now. You're wiser.
Your name was not taken.
I am wiser now, my lord, and I will not address your lordships. My friend will address.
No, for the client,
Sorry, sir.
we will not, but
I will not
your name was not taken, her name was taken.
No, I have no idea about what has happened.
Probably knew that he's developed cold feet. He knew that we are going to do something about what he did.
I'm very sorry.
Last day.
My apology.
We will not endorse it.
So my apology, my lord, that
Take our version as it stands and ask him if we are incorrect in any part of the version.
he has not informed me any of these things, my lord.
Why would he do that?
He was with the 3 days he has been, yesterday, day
I
before
don't
yesterday.
understand, but he is the creator of this anxiety. He's absolutely to be blamed with the manner in which he conducted himself on that day. He just assumed that without a senior, he'd just come and tell us we want an adjournment and we'll give it for the asking. Well, he's before the wrong court and he's barking the wrong tree.
No adjournment should be given for the asking.
And he had the documents with him, which he said he didn't have.
Oh, yes.
That was really very, very
Sorry. Anyway, my lord, my friend will address it.
We are discharging you. You can go ahead if you don't want to.
Very obliged.
Entirely your prerogative.
Very obliged, very good.
Yes, Ms. Bhattacharya.
The ladyship, the issue is, like right now I'm in a tough position as it is. And the issue.
We can adjourn it with the.
Like Sri Lanka, nothing on a hot head. Neither for you. All this background, we would still like to do justice to the parties before us.
Very well. I'm ready with the matter. We can go on with the matter.
If you think so, otherwise you'll put it full of. That applies to.
Or we can take a short adjournment.
Take a judgment, come on and say we are okay Monday, next Friday, whatever.
As a lady.
Tell you this background. And this background is imperative.
Yes, the lady.
When we are others and the members of the bar, they should also realize there is a way to handle the matter and the way to conduct themselves with the court. Right?
Let's,
We are not
on next
on
Friday.
these aspects, we are not two sides of a coin. We are the same side of the coin.
So
That kind of conduct doesn't behove a council, and anything we may do on a hot head would not behove us.
There's some things which have come out right now, your ladyship has
Well,
probably discussed.
it may not be taken as outburst. If somebody hurts you who is close to you, then the reaction is more. It was not expected from the bar. You are supposed to stand up for us.
Yes, your ladyship.
So then it hurts.
You're all officers of the court.
You are also the
First.
And that is why we are more reactive in that sense because.
Briefs come later. And if this is the way a counsel will conduct himself or herself, then it speaks
Between the
volumes.
bar and the bench, there is no trust and no openness and transparency.
He could have said, I've got the rules. I couldn't brief the senior. There's a problem. It came too late. You think we'd be callous enough to say that no, despite that, you argue it out? No. We do take umbrage in a case where counsels will trot in the morning, matter listed and say, now I want an adjournment. That's not being fair to us. Or we've told the other side, now we are telling you adjourn it. So big deal.
Ladyship, it seems to be that both of us have been taken for a little bit of a ride, so give me time to
We'll give you time for a week.
Parts of what your ladyship has just told me was not.
It was more of a frank expression of our anxiety and our distress.
We are candid enough to tell you this is what transpired. And candid enough to tell you, besides, I mean, I've never had this occasion. Brother has had to call me up. And I had boarded the flight, but for the fact that the mobile would not be switched off in a few minutes, and then told the court master to withhold the order because of this gentleman. To that extent.
I am so sorry, my lord.
Your sorry doesn't engage us, counsel.
You are practicing.
Be sorry to your colleague who you have not taken into the loop. Be sorry to your other senior advocate who knows nothing about how you conducted yourself. And most of all, be sorry to yourself for being unprofessional. Let's sit on next Friday.
Great.
Item 30.
Please. This is, my lord, I'm giving a short note, my lord, but before that, a little broad background, my lord. So this is regarding an option between contributory pension fund, provident.
Just trying to remind ourselves, they probably
Yes.
listed you on a particular point.
Yes, my lord, your ladyship, and my lord's question was this, that why give this benefit from the date he opts and not from the date of retirement? I think that was the question. Very truthfully, my lord, your ladyship will remember after I give the background. This was the question. Lord, here there were two options earlier and even today. Either you go for a contributory provident fund or you go for a pension scheme. Lord, in the year 1990, when this officer was in service, Lord, option was given, but the option was similar to the present option, that whatever is the provident fund contribution of the employer, namely the RBI, you will refund with 3% interest and 6% interest, and you will get the pension from the date of your retirement, not from from the date of your option, not option. Yes, not from the date of your retirement. But that was extended in 1992. The first choice he did not opt. These are all options. He's not under any obligation. The first option he did not opt for. It was given in 92. He did not opt for. But in 95.
Just a minute.
If the Honorable Court can come to page 20, this was the provision. 95, again we gave an option. He was there, working there, but option was of course available to everyone. He did not opt, but I want to show the provision. Page 20, bottom, para 17. My lords, get it? Your ladyship.
20 bottom. Yes.
Page 20, bottom. Not only the above previously similarly situated employee that exercised the option, dealt with a communication dated 14/10/95, granted the benefit of employees subject to the following conditions. The refund of Bank's contribution to Provident Fund with accrued interest together with simple interest at 12% per annum thereon from the date of payment till the date of refund to the bank. Thereafter, please see C.
They will be entitled for
full pension from the date of their retirement. The reason is that you have about say 50 lakhs of approximately given lump sum which you have invested somewhere, where at that point of time that you must have earned the interest of 12%, and therefore you repay the contribution and you start getting the interest. Now, my lord, this scheme again, my lord, because of the representation of the employees, and there would be about 2,200 employees who will be affected by this.
Watered down.
It is now 131. No, but same scheme continues. Only but we have reduced the interest.
No, Mr. Mehta, but this C remains. Eligibility for full pension from the date of retirement.
No, that scheme goes. That was in 95.
Yes. So what is this? Now we are looking at a.
Now your ladyship and my lord are looking at
95 he did not opt.
He did not. There were three options. He did not opt. Okay. He retired in 2014. Thereafter in 20.
So he opted for CPF. He opted for CPF.
He opted for CPF and he obtained the money, and I'll give the figures also.
All benefits under that scheme.
Yes, he got the benefit of 47,92,000 in lump sum in 2014. Right? He must have invested somewhere, etc., etc. Now in 2020, 6 months after his retirement, a new option is given because of the representation made by the employees, which your lordship and my lord, the ladyship and my lord would find at page 130. It is same, which used to be given earlier with a reduced rate of interest. This time, but they have to pay us at a lesser rate. It was advantageous to the.
Maybe, but you don't keep that clause this time. That from the date of retirement, it says the day you pay money. That is
yes. But please see para 3, clause 3 of page 130.
Yes, please.
The option for pension by serving employees, retired employees, and family members of the deceased employees is subject to certain terms and conditions to be specified. On exercising option for pension, the retired employees and family members of the deceased employees will be eligible to draw monthly pension, family pension, with effect from July 1, 2020. It may be noted that no arrears of pension will be paid for the period prior to July 1, 2020.
Accept notice.
So, just for understanding,
Yes.
from July 1, 2020,
20.
they will get the benefit of monthly. But what regard to gratuity and all, that they will get?
Actually, it's not in the picture.
That's not the question.
Pension Gratuity separate than CPF.
Gratuity he will get.
All that he will get. All
That's not in this.
Only
Figures, not figures. That's just not few figures.
All right, but we should notice.
only monthly family pension is from prospective to 1st July 2000.
Okay.
That's right.
Because the difficulty, there are several employees who are demanding now based upon
You're saying it will be having a ripple down effect. You understand? So today, what is the situation? What is he getting?
So he is getting the salary, he is getting the pension of about 1 lakh per month.
No, on the basis of the
1st July 2020.
Yes, Manoj. And please see, Manoj, the figures. Figures are, Manoj, little startling, Manoj. Therefore, Manoj, I'm giving them. But just come to the next page. So entire pagination is not relevant, Manoj. Come to Manoj, para 10 at the next page. Back side, Manoj. Back side. Back side, page, para 10.
yes.
In the present case, the petitioner on retirement received a total retirement benefit of rupees 47,92,000. Out of that, the employee's contribution on provident fund is rupees 16 crore 55 lakhs. 16 lakhs 55,000. The petitioner refunded the employer's contribution of rupees 16 lakhs 55,000 along with interest at 3%. So 3% interest is 2 lakhs 73,000. Which he returned. Now, currently he is drawing a pension of 97,500. If arrears is to be paid to him from the date of retirement, it will come about 40 lakhs. And many people would not have opted for this.
That is only limited to the monthly pension. The rest, whatever rest is there under the same.
Yes, that's not there.
Accepts notice. Contract with the filed within 4 weeks to rejoinder 4 weeks. In the meantime, the operation of the impure order entitling the respondent number 1 to pension from the date of his retirement, that is 30th of November 2024, shall remain stayed. However, it is 14 shall remain stayed. However, it is clarified that the respondent shall be entitled to the pension for on a month-to-month basis.
With effect from 1st of.
Yes, with effect from what was the date?
1/7/2020.
Along with any other benefits under the pension scheme.
It's not in this.
That's not, only this part.
Yes, sir. This is the only dispute.
Yes.
My lord, I may be allowed to submit 2 points.
Not in now, you're on KBA doesn't mean you hear you back.
Anything else?
Whatever he said, whatever he said, if there is anything wrong, he has submitted, I should be able to.
No, but what is the incorrect statement? Oh, everything is on record. What is the incorrect statement? What is the incorrect statement?
The detailed counter for us to understand. It's only item order.
My lord, give me 1 minute, 2 minutes.
Okay.
My lord, here the case is, my lord,
The council is permitted to carry out the necessary correction and file.
You filed an IA for that.
It is not just an IA. Only a letter. You've not filed an IA. You've only intimated the registry.
For your mistake, you are intimating only,
When I file an application, necessary corrections shall be carried out in the memo of parties. And the amended memo of parties on the contempt petition be brought on record within 1 week. Now, did we issue notice on that application?
But if the notice is issued and the matter of time is first to take place.
Right. So then list on the date fixed. That's all, list on the date fixed.
Apply before coming on the next day.
Next.
Item 63, grateful minutes. It's coming up notice.
Yes, please.
But the respondents no longer appointed as clerk cum paraphrase in 2009. In 2010, there was change in the management when we had a review of the decisions taken by the earlier management. And then we found that these 3 employees did not have the requisite qualification, which was not.
When were they employed and when did you discover it? They were employed on?
2009. It was 25th February 2009.
Yes.
And within a year, we found that they did not have the requisite qualification. We called upon them to produce the certificate. They failed, and thereafter, on 23rd of February 2010, we terminated the services. They went to the college tribunal. But during the pendency of the college, appeal before the college tribunal, they passed the examination, almost after a period of 1 year. That is also not sufficient because the qualification is that they should have an experience of typing in English as well as Marathi. So their certificates are at page 66, 68 and 70. I can see that those certificates, but they have passed only one. That also during the pendency of appeal before the pendency page 66. But this Mr. Barela has passed.
Just.
I'm sorry.
66. Yes, 66.
But this is not certificate submitted by the Barela before college tribunal. But he has passed examination in only English in the middle portion. He has not passed an examination in Marathi. Now finally, page 68, another respondent. But he has passed examination only in Marathi, not in English.
68 or 67?
67 is the type copy. I am pointing out the original.
See the type copy. Rarely see the original.
Type copy is 69.
Ajay Gopal Rao.
Correct. Ajay Gopal Rao.
Yes.
Original certificate is page 68. I am referring to original certificate. Others are not type copies. 68, he has passed examination in only in Marathi, I think, not in English. That's the reason that's the reason why I am pointing out the original certificate. That is the reason why. 60 certificate, I am referring to. 67, yes, there is a reason I forgot.
Yes.
Stand up to page 70. But this gentleman,
Again, typing error in page 69. Huh? Again, it says English typewriting, whereas you write in Marathi typewriting.
Or
yes,
What translation does
same confusion.
translate from there.
they're translating it?
Apologies for that.
Only names I change confused the entire thing without looking at the document.
I accept my mistake about that. Page 70. I noted it as the reason I'm requesting your worship to go to original certificate. 70. But now this gentleman has passed only Marathi typing examination. He has not passed examination in English typing. The rule says they
Both were required. Rule says both were required.
yes, both are required.
Both are required.
They have no option, they need dependency of the office. That means they did not have it.
What was the reason?
This requirement was not published. That's why they say that.
Not a condition in the advertisement.
Yes, advertisement there was a defect. It just said clerk appointment was given.
You withdraw that advertisement and a fresh one was issued. On the incorrect advertisement was the basis of their appointment.
Advertisement was incorrect. There was a defect in that.
Then, who should be blamed? Management. Why? They applied in terms of the advertisement. When the advertisement dropped the words, the requirement of passing the typing condition was not ratified by the management at any stage.
But the appointment was not published.
In the advertisement, it was only English typing.
Advertisement shows the advertisement.
What was that? English typing.
There you see the advertisement.
Where is the
Advertisement page 39.
Translation reliable at page 39, considering what has happened.
You don't discuss this translation, council?
Is it translation reliable?
Which is not
97.
And page 14, along the table, the first, this one is only about this Indian clerks.
Yes.
The number of post 3, SSC pass, experience of work on computer. But this requirement at particular speed in Marathi and English is not there.
And you
No. But the terms and conditions service shall be as per the rules of the government.
That's right. It's there.
Applications.
of service. Terms eligibility will also be as well. Where is Terms and conditions of service.
Service.
What about eligibility?
Is there anything to show that eligibility was fixed either by a rule under Article 309 of the Constitution, friend?
Yes.
Regulations or the any statute?
The normal rules which are applicable to the government, which are, that's the reason I filed an additional document. Can you see the additional volume? We even sought guidance from the Joint Director of
Also, which code did they apply?
Junior
Clerk, library clerk.
Junior clerk.
Yes,
Senior clerk, lordship, plus library clerk. And it was a misleading statement that it was advertisement for junior clerk from typist.
It's not like this.
No, but even for this senior clerk and library clerk, what is the requisite?
When eligibility,
Lordship was minimum qualification is given at
no, maybe in the advertisement, but actually what is it? Where do we get that from? Shows?
yes, I'm filing the additional documents.
Let's see. Wait.
I must fairly admit, these are the rules of 2017 framed by the government. But I'm
17. What was the relevant point in time when the advertisement was issued?
good.
What according to you the relevant?
That's on page 10, if you have the additional volume, we sought guidance from the Joint Director of Higher Education. He says that this is the qualification. Page 10, at the bottom, if your option says.
Page 10 of the additional document?
Additional.
Yes.
Yes. Now, kindly see last 3 lines. For the post of junior clerk typist and in direct recruitment, it is necessary to have minimum 40 words per minute typing eligibility certificate.
No, but this is current. What is the date? What's the date of this document?
This is 23, October 23, because I asked them to see the guidance from the Joint Director.
But what, at that point in time, when was this advertisement issued?
This is 2009 or 2009.
9.
Why not?
I don't know, but it is mentioned that standard code rules 1984 prescribed for non-acceptable.
I could have given on pages 15 onwards, Lordship. Standard code rules. Rule 7, sub-rule 2, 3, 4.
Page 15 of the immune judgment.
Lordship.
Come, let's see that.
But I know that not any funding in regard to
We'll
qualification.
look at it. Page 15, just trying to understand. Yes, please. Where in 15? Let's see the extracted portion.
Page 16, 16.
Para 17, Lordship.
Para 17. Para 17.
Page 16.
Or Para 17.
Which page is para 17? Page 15.
Page 15, bottom which starts.
Right. Para 17. Rule 7.
Rule quoted, is quoted on page 16.
Let's see.
19 codes 19.
This is probation. Probation nothing to do with eligibility.
We are not on the appointment. We are pre-appointment eligibility.
Relevant rule is sub-rule 3.
Sub-rule 3.
Is it there on record somewhere?
Lordship, page 16.
16.
Page 16, sub-rule 3. Rule 7, sub-rule 3.
Head of the department. You're reading that. Head of the department.
May I give Lordship?
That has nothing to do with
Assessment of performance, it is the document.
assessment of performance. We are on eligibility, please.
Initial entry at entry point. What is your
Self. Coming back to what you showed. Page 10. Yes,
it has
please.
been
Yes, page 10. Lord, noted, by the Joint Director issued to
Where's the standard code rules prescribed for, you're a non-agricultural university.
standard code rules, Lord, they do not provide anything. Lord, the rules which are applicable to the normal state government servants were unfollowed as regard to qualification of
No, please, but
that is what is stated in this.
as I understand correctly, if I'm wrong, it says, read the para as it stands. Accordingly, as per the provisions contemplated under the standard code rules prescribed for so-and-so universities, for the post of junior so-and-so, it is necessary to have minimum 40 words per minute typing eligibility certificate, but it doesn't say what language.
From the next paragraph, if you have page 11, Lord, he continues. Also, as mentioned in reference number 2, Government Gazette, as per
Yes, but that is 17.
Rule 17, the candidates must have the commercial.
Rule 17.
Lord,
This is a
2008.
appointment.
this,
No, council. It is junior clerk typist. Here it is only junior clerk.
that is not, as I pointed out, there was a defect in the advertisement. Their appointment order is also for typing.
Do you mean to say that there is no separate post of junior clerk by itself?
Yes, so kindly see the appointment order, page 41.
Yes to what?
We are
There is no
asking you-
post of junior clerk standalone, it's a junior.
Well, they are required to do both the works. That's the reason why they are
The
appointed.
council, that is not the query. We are asking you, in these codes, is there any category separate only junior clerk, or it is only clerk? Wherever it is clerk, it is junior clerk typing. That is the only nomenclature in the entire code of 1984. Is that the position or no?
Well,
Have two separate categories also.
Another question, where you're saying refer to the appointment letter, which is February 9. When you acquire those particular,
Post their appointment, post their
post their appointment. So they were really not, when they were appointed, at least the appointment letter, first para says post of junior cum typist.
Some typist. Well, typist who are
You acquired your,
Lordship,
you acquired your.
No, is it your case that the appointment letter, maybe it has named you the junior clerk typist, but the advertisement was not for typist.
Lordship.
You may mention anything, it may point me, but eligibility, how can you make them ineligible on that ground? You may issue, you may write anything, whatever you want.
Just because there is a mistake in the advertisement, well, rules.
You had the power for which you are courage now.
Rules can't be diluted.
Should I know it? Should I?
Anyway, you have to just clarify this down.
This aspect, to clarify this, we are issuing notice limited to this.
Notice is
Sorry, we have
already issued.
notice limited, but we have not, we have issued a.
It's coming up the notice.
We have issued an open-ended notice, only on this aspect you need to clarify. Then why did you undertake those certificates later? When you, what kind of work were you doing?
Lordship, may I explain?
Yes,
Lordship, we were given termination letter
yes,
on 23/2/2001, and as per that letter, we were asked to produce the past certificate within 3 days. Well, it wasn't a condition in the advertisement.
Assuming,
What
what was the nature of work you were doing?
Lordship, we were assigned work within the library.
No, but it was a junior clerk cum typist even as per the letter.
Lordship, we were assigned work within the library, Lordship.
Who may have?
No, but the appointment was
Junior clerk cum typist as per the letter of appointment.
Lordship, we were conveyed
They may make you do work is different, but your appointment
You
was.
had to be ready for that.
Lordship, we were working on computers also. We had workable computer knowledge, Lordship.
You have to assist us. But give us this distinction. Do you have the rules? 84 rules.
Give us those rules, please file them. Please file them. Say that, permit this application, allow the application, take on record the documents, additional documents, say, learned counsel for the petitioner is directed to file a copy of the Standard Code Rules 1984 referred to in the letter dated 15, what is it, 15, what? 2000, look at the dates. What is the date of this document? It says 15/53/03. Or whatever it is worth.
11/10/2023.
Wait, where is this a typed version again of a letter or is it original?
You are also referring to the additional notice?
Annexed to 17, last page.
Yes, no, last.
What is the date at the bottom?
Yes, there is no date, it's 11/10. and
Dated 11/10/2020.
Yes, and that is timing.
All right, 11/10/2023, bracket and annexure P17 with a copy to the other side. List of. And you can put it on NMD day, don't put it on a Monday, Friday, NMD day.
Well, I also produced it, but the government is also here there.
And counsel, even if the rules are silent, minimum qualification says SSC pass experience of work on the computer.
Lordship,
It will mean that you have computer typing is the basic starting point of a computer.
Let us see what, we have to examine this.
You'll have to come clean on that.
Yes, next.
64.
64. Yes, please.
This matter, my lord, what had happened was there was some lack of statute with regard to appointment of registrar. Now we have framed the statute. So my lord, now it will be governed by the statute which has been formed for the registrar, which is qualification as prescribed under the EGC.
What the state?
I am the statement.
They are the university. Petitioners are the university.
So I am in 64-1. I am one of the candidates who have applied. Then when the rules were not framed, 64-1.
University is here.
University.
As I appear for the contesting respondent, 17.7 order of my lords.
Yeah.
So you have come up with the rules when?
2021.
My lord, I am appealing for the university, my lord. Now the rules have been.
And he is saying that now with the rules, now this matter become academic. Why should we take up that?
My lord, the only issue that remains, if that part of the impugned judgment where the High Court has directed to reinstate the respondent number 1 and pay the wages, etc., my lord. Since he had not worked, it was not, he was not holding any.
But that period has also expired now. That period has also expired now.
No,
that period for which he would have worked or the entitled to work has also expired.
My lord, it may be clarified in the order, my lord, that he will not.
I am contesting that position. Page 22.
Mr. Surekant.
My lord.
Surekant. Till the rules were in place, he continued to work, or didn't he?